Court will note the appearance of Mr. Todd on behalf of the plaintiff, defendant appearing in pro per. There are two matters before the court: the plaintiff's motion for temporary custody, parenting time, and defendant's motion to determine child born out of wedlock. We'll address Mr. Todd's motion first. I guess I'll ask Mr. Derman, in consideration of your motion, are you contesting or disputing custody or anything?
Your Honor, I'm disputing the custody of the oldest child.
Okay. Okay. Then go ahead, Mr. Todd.
Thank you, Your Honor. Your Honor, the parties separated in September when a PPO was granted. Since that point, the PPO has in fact been violated. Since separation, defendant has had no contact and no parenting time. The motion actually is not necessarily accurate at this point. Mr. McDermott did request some parenting time in late November, and my client indicated that that would be fine as long as it was with a third party neutral, or alternatively, it could be supervised by his mother. We do believe it's in the best interest of the children for mother to retain sole legal and sole physical custody, with parenting time only being supervised. We've outlined those reasons in the motion. Defendant has not spent one overnight alone with the children ever, including prior to separation. Defendant has significant anger issues. He has chased one of the children up the stairs, saying he will beat their butt. That child was 6 years old. We have a recording of this. Additionally, defendant has a pretty significant criminal history. He pled guilty in 2023 to assault with intent to do great bodily harm less than murder. During this particular incident, he was drunk. He forced plaintiff downstairs, holding her hands behind her back, and began to choke her while she was calling 911. And also he had a hatchet and was threatening her. Defendant has uncontrollable fits of rage and anger. Additionally, he cannot provide a stable or consistent environment for the children in any way. In June of 2024, there was an incident where he was drunk, put the children in the car, and then proceeded to do burnouts. In July of 24, there was an incident where a defendant threatened to murder someone. The children woke up during this incident, and then defendant started to yell at the children. Later in July of 2024, there was an incident where a defendant was drunk, yelling at both plaintiff and the children, calling them pussies, and saying that he would teach them a lesson. We have a recording of that. In August of 2024, there was an incident when defendant was drunk. He cut off the power to the home, and plaintiff woke up. Defendant had jelly covered on his face and was holding a knife. We have pictures of this incident as well. Additionally, there was a hit and run, which defendant admitted to, and we have this in recording. Given all this, we believe it's appropriate that he obtain a psychological evaluation and comply with any and all recommendations prior to any unsupervised parenting time. This behavior is continuing to get more aggressive and worse and uncontrollable. Alternatively, my client is a stable income as a teacher and a stable home for the children, has a strong connection with the children, and we are requesting child support to be backdated from the date that we filed this. So in total, we're requesting sole custody be given to my client, defendant complete a psychological evaluation and comply with any recommendations prior to unsupervised parenting time, but he can have supervised parenting time through a third-party neutral, or alternatively, his mother, and we would respectfully request that that be limited to 3 hours per week.
Okay, thank you. Mr. McDermott, what's your response?
Your Honor, well, she's accused me of being extremely intoxicated multiple times, even to the point where telling my parents that I'm drunk in the driveway. And my dad actually would come over and make surprise visits and find that I had not drank anything. I was not drinking during the burnouts. When I got arrested for putting my hands on her, I went through the entire program, and she dropped the charges at the day of my court date, and the state picked it up. I went through their entire program, was released off probation early, and I was even offered a job. The reason I've had no overnights is because I don't quite understand the PPO, and I was seeing my children at the house up until 11/17/24 when the talk of splitting items and divorce came up. And I do have this on recording. And then 11/24, she had canceled on me. I had a visit on 11/25, a video visit. And all these incidents where apparently I was drunk and obscene, my question is, how come the police were never called then if I was such a danger? And I apologize, Your Honor, for this, but I did actually go to Berry County mental health and had an evaluation done, but I didn't get my letter back until Saturday, so I wasn't able to send out the appropriate copies. But I do have that, and I was going to send those in today.
Okay. Great. Thank you. Anything else, Mr. Todd?
No, Your Honor, but I guess just the PPO does allow for peaceful contact as it relates to the children.
Well, what the court will do in the interim, the court will grant to the plaintiff legal and physical custody support pursuant to guidelines to the date of notice of your motion, Mr. Todd. Court would allow supervised parenting time for up to 5 hours on Saturday from 12 o'clock noon to 5 o'clock p.m. That can be exercised at his mother's home or at some other third party that the plaintiff would approve and agree to. And Mr. McDermott, you'll have to provide that psychological evaluation to Mr. Todd within 7 days of today's date.
Yes, Your Honor.
That will take care of that part. Mr. McDermott, now we'll address your motion to determine child born out of wedlock. Go ahead, sir.
Well, when I had met the plaintiff, she was already pregnant, and she kept his real father out of his life for about 2 years. And after that, I mean, he has been seeing him all the time. He's over there almost every weekend. And I just don't feel it necessary for me to have to pay support when his real father is seeing him consistently. And as far as me signing the birth certificate, be honest, I really didn't even know what I was signing.
Yeah. Well, that's unfortunate. Okay. Mr. Todd had filed a response which was consistent with what this court had was thinking when I found this. Mr. McDermott, pursuant to the statute, which is 722.1441, you're required to take action and file your action within 3 years of the child's birth. Child's 8 years old, so you've missed the statute of limitations for filing this action. What's your response to that, sir?
Your Honor, I was not aware of that.
Okay. Well, unfortunately, whether you're aware of it or not, it's still the law. And as a result, the court can't just ignore the law because you weren't aware of it, unfortunately. So the court doesn't find any basis at the current time for your motion in this matter. So I'm going to deny and dismiss the motion. I'll ask Mr. Todd that you would prepare an order to that extent, as well as a motion on the other the matter. It might be better if you did them separate, that way.
Sure.
Rather than just one order.
Okay, absolutely.
Okay, that will be the ruling of the court, and you're free to go and have a good day.
Oh, I apologize, Your Honor. One other thing, can I request an exchange of income within 7 days?
Yes.
Okay, thank you, Your Honor.
Yeah, Mr. McDermott, send to Mr. Todd proof of your income and he will send the same to you as proof of the plaintiff's income.
Yes, Your Honor.
Okay,
All right, so imagine that one. Imagine it's not your kid, but you're going to end up paying child support for 15, 16, 17 years because you didn't sign some paperwork. Now imagine it is your kid and you're a piece of garbage who'd rather lie about it than pay the child support. So go figure with that. We got a whole bunch of them today. We got Judge Middleton, DeSanto, Judge McNally, Judge West, Judge Mogan, Mercer. Got a whole bunch of them. Welcome to American Courts. Thank you for coming out to the show. Let's jump over to Judge Middleton.
In the south.
Oh, yeah, I mean, I just sounded like there were just few people I had some contact
I
with.
don't
They're
know if
worried
they
about
have
their pipes.
de-icing equipment at the airport. As for the runway,
Oh, yeah, I mean, just-
here is business as usual. All right, Haskins was your maiden name, correct? All right, I believe the last time you told me Tepfer, but I'll go with
Yes.
Tricia Marie Haskins. The file number here is 242304. You're here with your attorney, Ms. Rhonda Ives. Also present is the Chief Assistant Prosecuting Attorney Joshua Robert. You were charged on December 28th with a domestic violence charge. I think I saw you on the last day of the year, and bond was set. Matter is set for an attorney pretrial for February 7th, which is the first Friday in February, with Ms. Ives as your lawyer. It is a condition of your bond that you not have any contact with the complaining witness here, Randy Tepfer. I got an email over the weekend advising me that you had been arrested for an alleged violation of that bond. Andrew Stahl, who's I believe a state police trooper, says they have reasonable cause to believe that on January 18th, 2025, which would have been last Saturday, that you violated your bond condition by having voluntary contact with Randy Tepfer. So you were taken into custody. My administrator was working over the weekend and scheduled this matter for today on an emergency basis. Ms. Ives was already scheduled to be here today. Now, while we're waiting, Mr. Robert indicated there was a plea offer in this case. And I'll state it as I understand it. You're charged with domestic violence first offense for this incident that allegedly occurred on December 28th. Domestic violence first offense is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Once your bond violation came in, the prosecutor took a closer look at this and realized that this is actually your third domestic violence charge. You had one in 2013, 13-311 SM, a domestic violence. Probation was actually revoked. It wasn't successful. Then you had another domestic violence in 2014, 14-1443 SM. Those are just the ones here in St. Joe County. I'm not sure if there's any others. Meaning the prosecutor could charge this as a felony domestic violence third offense, which is punishable by a maximum of 5 years imprisonment. Mr. Robert indicated if you plead to the misdemeanor first offense, they would not pursue charging it as a third offense felony case. Is that correct, Mr. Robert?
That's correct.
All right. And then there's also the issue of the bond violation. Ms. Ives, what's your client's position here?
I have discussed the offer with my client. My client at this time would like to plead as charged, considering the fact that the prosecutor could charge this and may charge this as a more serious offense. She's also willing to take responsibility for the bond violation as well.
Is that true, Ms. Haskins?
Yes.
All right, let me ask you a couple things. Anybody threaten you to get you to plead to this other than that plea offer I stated on the record?
No, sir.
Or promise you anything other than that?
No, sir.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Ives has been here pretty much since the early proceedings of this, would be here with you through the pretrial and through the sentence. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you, including Randy Tepper, subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
All right, let's go back to December 28th. You and Randy at that time were married, is that correct?
Yes.
And you were living together in Sturgis
Correct.
and on Vicky Drive. And on that day, did you and Randy get into an argument?
Yes, sir.
And he was videotaping this proceeding, which also just served to make you angrier than you already were.
Correct.
So did you strike him?
Didn't realize I struck him. I just tried to stick the phone on his hand.
All right.
He always does that when we get an argument. He'll try to record the end of it.
Well, he had some scratches on his head and under his eye.
I did not touch him. I did touch the phone. If I got anything, it was a hand, but I did not hit him in the face, nor the eye, or the head or eye, excuse me. Or the
Well,
phone.
maybe we'll take a look at the video, but striking him in the hand is sufficient
Right.
for a domestic assault. Now, it was a condition of your bond that you were not to have any contact with him.
Right.
On the 18th, did you go over to your house on Vicky Drive?
Yes, sir.
What was the reason for that?
To watch a movie and hang out because he missed me.
All right, this is one of those things that sometimes you need to get to the bottom of. There's a bond condition that you weren't supposed to have any contact, but did he allow you to come over there?
Yes, sir.
And then when things went haywire, then he
It
called.
wasn't even haywire. It was crazy.
All right, tell
Nothing
me.
even happened, and he literally just, I heard over the Bluetooth speaker, because he had it hooked up to his phone. He went outside. I heard on the thing, 911 dispatch, and then I flipped because I was in my pajamas getting ready to watch a movie, and then I couldn't find my keys. Once again, I hear him leaving with nothing, because I don't even have my phone or anything anymore because he's taking everything. But yes, that was my fault, and he said he was calling, and I tried to get out of there, and
Well, it doesn't sound like much of an aggrieved victim. Now, it says in the report that they had received 5 calls. Tricia advised she is fully aware she's not to be in contact with Randy for any reason. I advise that this is the 5th call of service involving Randy this month.
he's calling, not even under any distress. That's what he needs to get in trouble for right there, because that's.
All right, well,
what
he's not the authority to lift the bond condition. We are.
Right.
But this is very common. Now, I'm looking at, you've got a great big bruise on your right cheek. How did you get injured?
I got injured by trying to fix the curtain and I went to go jump doing, so I had to get on the couch to do it. And when I go to jump off the edge, I got too much bounce and then I can't even explain it. It was so weird. I ended up hitting the wall just with that cheek. I had 2 scratches
And where did this take place?
at our residence,
At Vicky Drive?
correct?
So how long had you been back there?
Off and on, I had stayed a couple nights. At first I was there until probably the last call. Or the first call, I don't even know.
I'm skeptical about your story about the bruise on your face, but
I would tell you, I've been mentally and physically abused. I promise if he did something, shove me or anything, he actually tried to say that the kid that was sitting on the couch did it. So you do have a word on that for sure that he has not did it. Because I was in my past with my children's father, and I wouldn't hide it back because that's no joke. I'm gonna get a divorce now because it's starting to get screwy mentally, big time.
all right. Mr. Aubert, do you have that video?
Well, it says our file has digital evidence, so
Well, I've got to provide notice to him. What she admitted to and what's in the original complaint are different. She admits to slapping him in the hand. The police report indicated that he had injuries on his face and eye and wrist. And I'm not sure that the fact that he was videotaping it just exacerbated the problem. Then I tend to believe her version that she was there with permission until he didn't want permission anymore, and then he wants to enforce the bond conditions. Nonetheless, this is a very volatile situation. She has 2 previous convictions. And she clearly violated my bond condition for this very reason. The state police got better things to do than get called out there 5
Exactly.
times because you guys can't get along.
Yes,
And somebody could get hurt, and you've got an injury to your face, and I'm not sure what the reason is. Ms. Ives, do you have another trip planned or anything? Are you gonna be?
Well, I'm around. I've got a lot of trials scheduled. Right now, kind of February is trial. I got a mediations and trials scheduled galore. I think I've got one coming up either here with Judge Pattison, but do you have a date in mind that you would like to come back and because I do have my calendar with me?
Yes, let's see what we've got.
If it helps, I am here on Thursday, January 30th at 11:30. I think I've got a PB.
Yeah,
for-
you're screwing me up. That's a terrible time and date for me.
Okay,
But the clerk put it in there. I called and said, who put this hearing in at 11:30?
sorry, sir.
I have a meeting at noon that I'm supposed to start the meeting, and I'm probably gonna have to cancel it or move it.
I will
So-
be here.
I'm gonna go ahead and cut it there. It's got 3 minutes left, but it's all just scheduling stuff. I was watching it earlier, and I didn't kind of pick up on how long the scheduling part was. No, it's not snowing in Florida just yet. It was snowing in Pensacola earlier. My wife's sister lives over there, and she said it was snowing. But where I'm at, it's just raining and nasty. I'm sure it's snowing somewhere. I had some folks in South Carolina tell me the roads were icy, and so if you're in one of those areas, be safe. We got plenty of court coming up. We're going to throw up a Judge DeSanto, and then we'll go to Judge McNally. So here's Judge DeSanto.
All right, please raise your right hand, ma'am. You solemnly swear from the testimony about to give this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
All right, and you heard the allegations that were placed on the record, correct?
Yes, Your Honor.
As to the allegation you tested positive for cocaine and you had a diluted sample on one of those tests, how do you plead?
Guilty, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
And counsel, if you can please go to your client.
Ms. King, are you currently on probation out of the Wyandotte District Court?
Yes, sir.
As a term and condition of your probation, are you to not test positive for any drugs or alcohol?
Yes, sir.
Did you in fact test positive for cocaine on December 8th of 2024?
Yes, sir.
And did you have a diluted test on December 26th of 2024?
Yes, sir.
And you understand that those are both violations of your terms and conditions of probation?
Yes, sir.
I'm satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violations. And as to the recommendation, counsel.
Yes, Your Honor. I'm simply just asking for one last chance for Ms. King to complete all the terms and conditions of probation. She understands the seriousness of her actions. I would like you to know that she's a single mother of two, that her children would have absolutely nowhere to go at this point in time. She did take it upon herself last week to enroll in outpatient treatment. She's going to be starting that, and we would just be asking that any sort of jail time, because it would put the family in a very horrible predicament. I did explain to her that her choices are the reasons why she is in this predicament. She does understand that. So moving forward, Your Honor, she's going to do everything in her power to not put herself in this position again. So I would just be asking to suspend any sort of jail time at this point in time.
Well, counsel, I already suspended 10 days, and then I already held one in abeyance, and now we're here again. Ma'am, where do you work?
Your Honor, I'm a waitress, which I've already spoke with my boss, and unfortunately he would not be able to stay my position there if I was to have to go.
Okay, and how old are your children?
My son, he's right here. He's 11, and my daughter, she's leaning on me. She's 6. They
Why
didn't
do
have
you
school
have
today.
ma'am, why do you have your children right with you when you're here?
I have an AirPod in. They cannot hear what's going on, and unfortunately, they're in their living room. They just came down.
Okay, and so who watches your children when you go to work?
Normally, Your Honor, I work more of a day shift, so that way I'm off by the time they're out of school. I go in the morning time, and I get off around 2:30. My son's released from school at 2:45, and my daughter's off at 3.
So no, you don't ever have to have somebody watch your kids?
Occasionally my cousin Camille does if I work like a night shift, but she lives all the way out in Monroe.
Well, you're gonna have to give her a call because you're serving your 20 days, ma'am. And you're gonna be tethered to treatment because you clearly need it. You clearly need it.
Your Honor, I cannot. I'm on a month-to-month lease. I will lose my home. I will lose everything.
Ma'am, stop right now. Because I've already given you a number of chances, which clearly have not been to your benefit. Because here we are again, 2 positive cocaines again.
I understand that, ma'am, and I'm very sorry that I have to come in front of you on this. I know that you know my situation of back what happened in August with the abortion and things like that, and that's what the fentanyl was. Me and Brandon, proceeded to end our relationship, and he's no longer here. And in December, I fucked up.
I'm sorry, ma'am, you're in court.
I didn't mean to cuss.
You cannot talk like that.
I did not mean to cuss, Your Honor. I made a mistake, and that was when the baby was due, and I relapsed. I was 14 months clean on cocaine, and I'm sorry.
Ma'am,
I literally was 14 months clean.
You're serving your 20 days. Your under advisement will be revoked. I'll give you until Friday so you can make arrangements for childcare, but you are reporting on Friday and you're serving your 20 days. You're going to be tethered to treatment because you need treatment. So 10 days on the probation violations, 10 days from the previous jail review.
I don't know what I'm going to be able to do, but okay, ma'am.
I'm sorry?
I said, okay, ma'am, I don't know what I'll be able to do, but okay.
Well, what I know you're going to be able to do is report to jail on Friday. All right, good luck to you, ma'am. Please email into Ms. Shaw by 11:15. Ma'am, did you hear that?
I'm sorry, no, I did not.
Please email into Ms. Shaw by 11:15.
Email what in?
Email into Ms. Shaw by 11:15. She can give you the information on reporting.
Okay. So I have a question. So after the 20 days, what happens then?
Then you're released. Then you have to enroll in intensive outpatient. You're still on probation.
Okay.
Okay?
So I would still be on probation for how long?
I don't remember what
Because I was up for early release 3 weeks ago. So as of now, what am I going to be doing? I don't see how this is going to help somebody, but all right.
You don't see how what's gonna help somebody, ma'am.
How jail time is going to help me, if anything, that's going to put me back behind more and possibly lose my children, my home, my house, everything. So I just don't see how that's going to help anybody. And if someone is struggling with addiction, that isn't going to help anybody. So this is just, I just feel like this is up for failure at this point, Your Honor. So I take in what you're saying, and I just want to know what else is going to happen with my probation afterwards.
Ma'am, did you hear me when I said you're going to be tethered to treatment?
I don't, I'm going to be what?
Tethered to treatment. So you're going to report to the jail, and then they're going to place you in an inpatient treatment facility. That's how that's going to help you, because on your own, it appears to not be working very well. So this way you can get the tools so that you can stay clean and sober and in active recovery for your children and yourself.
Right, but you're saying that I have to do the 20 days and then go do that. So how long am I looking to need to have childcare lined up for my children if you're telling me I need to have lined up by Friday?
You're not listening to what I'm saying. I don't think you're understanding what I'm saying.
I'm not. That's why I'm asking questions.
You're going to report to the jail on Friday. They're going to book you in. Then they're going to send you, within a day or two, they're going to send you to an inpatient treatment facility. So your jail time is going to be served at the inpatient treatment facility.
Okay.
That's how that helps you.
Okay.
But your choices have you where you are right now. So do not try to guilt the court as to how that's going to happen or anything of that nature as to what's going to happen if you end up losing your job or whatnot.
Their father just lives in Genesee County, so I just don't even understand how they're going to be able to actively follow in school. Like,
wait, what?
Their father doesn't even live in Wayne County. Like, my dad, nobody lives in Wayne County. So these kids are going to be having to miss school for 20-something days.
And make the appropriate arrangements. Contact your cousin. She's local.
Local, that's Monroe County. That's a whole different other county as well. I mean, I just don't understand how I'm going to be able to balance this out. And at this point in time, I really don't. So
depending where she's at in Monroe County, she could be 20 minutes away. So I don't know. But in any event, ma'am, you knew what the consequences could be. You knew that. You already had a jail review. The court already suspended your jail on the bond violation. The court held your other 2 probation violations in abeyance. So this is what it is. So the court had originally had you on probation for 18 months. And that was April 3rd. So you're not even at your 12 months yet. So you're still on so you'll still be on probation. Even if you're eligible for early discharge from that 9-month mark, you have to wait another 3 months, make sure there aren't any other violations. So to answer that question, okay? Email them to Ms. Shaw within the next 5 minutes, please. Good luck to you. Thank you. All right,
That was some amazing entitlement. I've never seen somebody so willing to argue with the judge, and Judge DeSanto's not one to argue with because she'll argue right back. She just keeps going and going and going, but then again, this lady may be partaking at the moment, so who knows? She's obviously not worried about going to jail. She keeps doing drugs, so I don't know. We've talked about it several times. I'm not much of a drug person, but I didn't know you took cocaine to escape pain from life. I thought you took cocaine to party. So maybe I'm misunderstanding my drugs and need to go back to school on it. So I'm going to jump over to Judge Mercer just because it's a little lighter tune, a little funnier. So let's jump over to Judge Mercer.
Good morning, Your Honor.
Ms. Mendez, good morning. Ms. Mendez, let me get to your case and have it pulled up here. I The state at that time was asking for essentially first offender probation. After looking at Ms. Mendez's criminal history, I determined she had at least 2 prior DUIs and had one pending in Alabama. And there were a couple of more possible DUIs in another state. So I was not comfortable with the recommended sentence, but I wanted to get more information. So I set it for sentencing yesterday at 8:30. Ms. Mendez did not show up. However, her brother did get her here maybe 45 minutes later and explained that he had vehicle trouble and it was not Ms. Mendez's fault. So based upon the likelihood that I was going to impose an incarceration sentence anyway, I asked that Ms. Mendez be taken into custody and we would see her this morning for sentencing. Mr. Mendez, tell me about what you're requesting as her brother. I know that you expressed some concerns when she pled about these were reoccurring alcohol consumption related crimes. So tell me what your position is.
First, Your Honor, I do want to apologize again. There was no intent to disrespect this honorable court.
I understand.
For yesterday.
Appreciate that.
My sister spent a good majority of her young adult life, just coming into her adult life in a college town, which she kind of had a hard time leaving. 9 years spent there, 7 of those years educating herself at Rutgers University in New Jersey. And it kind of came with her. She's a great person, very amicable, and she actually has good intent for society. Her addiction is a problem.
2 things this letter mentions. One is transportation being provided to the program. Are you willing and able to get her there? The second thing is it says they require certain blood tests or a charge of $150. Has she had the blood test or do you have the ability to pay the $150?
Your Honor, the blood test has a turnaround time, which I felt was going to be a little bit unneeded. If the fee is just $150, I much rather come out of pocket for the $150 fee, let them test her there, which is what the fee is initially covering, is the cost of the blood work. Let them test her there and then let them have the turnaround time while she's in custody at that facility versus us having to wait for the local laboratory to actually release records.
Okay. When are you asking that she be allowed to go if I let her go there?
As soon as this honorable court decides it's worthy.
Okay. So anything else we need to know about?
No, sir.
Mr. Mitchell.
I guess the only question I have is the Teen Challenge program you said was for a year. Is that what it is? Is there any chance of getting out of the program or does she have to do a full year?
So the program is for 1 year, mandatory. She has to continue. The being on-site facility may not be a year. There is a minimum, I believe, from what they explained, of 3 months. It may be extended, but it is only merited any condition or privileges that she may have based on her advancement and process or progress within the program. But the program is mandatory for 1 year. There is a cost associated with that program, anywhere between $1,000 to $3,500 a month, which we are ready to pay. And that is.
Okay. I think that's all I have, Your Honor.
Mr. Goodson, what about the program? I know you've dealt with Teen Challenge before. How long is the inpatient portion minimum?
I haven't seen anybody with Teen Challenge.
Yeah, I want to make sure she can hear you, please.
Now, I haven't personally dealt with Teen Challenge in several years, but we used to send a lot of people to Pensacola. My understanding of the program then, that may have changed now, is there is a residential requirement. I think your name, sir? Mr. Mendez is referring to, my understanding is 3 months residential. And then the people that we have sent previously to Pensacola, they still remain on the facility, but they are allowed privileges like to go out and work. Sometimes most treatment facilities, 3 months to 6 months, they may be allowed a weekend to come home and visit, but they still remain in the facility. Now, correct me if I'm wrong.
That's correct.
Okay. Mr. Mitchell, what's the state's position?
As it stands right now, Your Honor, we have no objection to her entering into the Teen Challenge program.
Okay. And Ms. Mendez, now is your turn, ma'am. Anything you want to tell me or tell me what your thoughts are about this program that you've been accepted to?
Yes, Your Honor. I just, I would like to know if you were to sentence me to jail, what the duration of that sentence would be.
1 year.
Compared to a year in rehab program.
1 year, it'd be the same. The difference is I sentence you to a year in jail, you may or may not get gain time. You want to do a minimum of about 10 months minimum. I believe that calculation is about right. Is that correct, Corporal?
Yes, sir, that's correct.
Whereas if I sentence you to 1 year in the program, you've heard your brother say Teen Challenge is going to require a minimum of 3 months there, and then you're going to have an aftercare program, and who knows, I can't tell you any more about it than he already told us. Whether you would be living there, I don't know, but I would require you to complete the program because I want you to complete the program. And if you complete the program, then any balance of any incarcerative sentence will be forgiven.
I understand.
Any other questions?
I do have a question. If once I enter the program, for some reason I find that it's not working, will I have the opportunity to transfer to another program?
No, you will have the opportunity to come back and do your time in jail, though. No, I'm not going to let you jump from program to program. So you need to be committed to this program. If you decide to do this, if it doesn't work out, you don't like it, that's okay. You just go back to jail and you finish your time there. But we're not going to go from program to program to program. We're not going to do that. Any other questions?
Will I be allowed the opportunity to possibly find a program that may be closer to home, Dothan?
Sure. You're going to be in jail while they're looking for one. But if you want to do that, I don't have a problem with that. I'm not dead set on this particular program. But this is what your family is recommending. And if you don't want to go, the time to tell me that is now. You're going to be in jail. I want to sentence you today, and you're going to be in jail while you're waiting. It sounds like I have doubts about her willingness to complete the program based upon her questions today, but let her finish and we'll see if you want to add anything. Ms. Mendez, any other questions?
No.
Okay.
I can't think of any other questions. Right?
I'm sorry, Ms. Mendez. I didn't mean to interrupt you. I thought you were through. Go ahead, ma'am. What were you about to say?
I can't think of any other questions right now, Your Honor.
Okay.
I went over the specifics of what you would require yesterday with her brother and her, and I explained to her that if you were to consider that, that means she would stay there and she would complete the program. If she leaves, there would be a warrant issue for her arrest. If she gets kicked out of the program for non-compliance with their rules, there would be a warrant issue for your arrest. So she's familiar with the ramifications of not complying and not completing.
Okay. You want to add anything else, sir?
Yes, sir. Just so the court is aware, I will have power of attorney over her stay there. There is no jumping from program to program. This is unfortunately a withdrawal talk where things become highly anxious, and it's a mental state of mind of where she is speaking from that point and angle.
So given that, am I better off not letting her go today, but letting her go through this withdrawal period, as you call it, in jail, and letting her go next week if she wants to go then? I don't want to make a decision today, going to this program, staying a day, leaving, and then having to do the year in jail. I don't want to do that.
So the program itself has a 21-day hold where there is absolutely no communication with the outside world for that purpose. And it's guided counseling withdrawal where she would have someone to, and it's a faith-based program. So a lot of it would be based on going to church and understanding where she is in life and how she can become a better person. And I truly believe that the betterment of that withdrawal will be served within that 21 days.
Okay. So Ms. Mendez, I want to sentence you at this time. I'm going to go ahead and sentence you to 1 year in the Jackson County Jail. I'm going to give you credit for the time that you've already served in jail. And that amount of time is how much, Corporal?
15 days.
15 days that you have credit towards that sentence. I'm going to impose a standard court costs and fines. It's in misdemeanor court, so we'd treat it as a third offense, DUI, which is, she actually has more than that, according to the criminal history that I've got.
2,600. Well, with the, since she has John today.
No, she doesn't have John today.
All right, so $2,553.
$2,553 court costs and fines. That'll be a civil judgment. That's the sentence. Now, where you serve that program is up to you. Okay, I'm just sentencing you to a year in jail. I can't force you to go to a faith-based program. I'm not even going to try. If you decide to go to that faith-based program or to a different program of your own choosing, I would consider it depending upon the program. The factors I would look at is how long is the in-house residential portion of the program. That's one of the key factors I look at, as well as is the program going to work with probation and notify them if you leave, those kind of things. So you do not have to make a decision today. I don't have a problem with you saying you want to think about it. You want to ask your family to look for a different program, that's okay. But if you know you want to go to Teen Challenge in Columbus, Georgia today, then I'm going to address that now. So do you want to make a decision on going to this program in Columbus now? Or would you rather your family to look for other programs over the course of the next several days and me see you again next week and see where we stand?
Judge, can I make a suggestion that she talk to Chaplain Pippin? Because I know we have some non-faith-based, and I think that is the issue, is the faith-based part of it. And I know we may have some, I prefer maybe, I think it might be wise to let her talk to Chaplain Pippin and see if there's
Ms. Mendez, would you like to talk to Chaplain Pippin before making a decision then?
Yes, Your Honor, I would appreciate it if I can speak to the chaplain, see if he is aware of any programs that are similar, closer to Dothan.
Yeah, and the other programs, I think the minimum inpatient portion is 6 months, and they may not be designed strictly for alcohol, but we'll let you talk to Chaplain Pippin, and your sentence is imposed. That means you're getting credit for the time that you're there. So once speaking with him, I'll be glad to consider next week. We need a little notice. Corporal, if we're going to see her next week, I need some notice so we can give her brother notice of what's going on. So if you'll leave your contact information with Mr. Goodson in the probation office. But right now she's doing the jail sentence, and if she finds a program that I want to pick somewhere that she's going to complete, because if she doesn't complete, everyone in the courtroom knows what's going to happen. It's what I do. It's what I'm going to do. If she leaves that program, she's going to finish the jail sentence. If she gets kicked out of the program, if she gets caught drinking alcohol while she's in the program and they kick her out, then I gave her a shot. That's all I can do.
I agree, Your Honor. It is up to her. She is not all. What I would like to make clear for the court is that as her brother, I'm not her brother's keeper, right? I'm not going to continue to come out and continue to have her have undecisive moments where she isn't looking to make a decision on her future. I have 5 children of my own from 21 years of age down to 7 years of age. And I'm not going to, there was a week elapse for this court, for her to find this program. And through my research, it was found and implemented.
I appreciate the effort you're putting in, trying to help your sister. And whether she takes advantage of that or not is up to her. My guess is you've helped her several times before, and it hasn't done much good. And sometimes they just have to find their own way. So she's got a year in jail. If she can do it right there at that jail if she wants to, that doesn't bother me one bit. I think it would be better for her to find a program that she will complete, because the fact is, without treatment, when she finishes her jail sentence, she's probably still going to have an alcohol addiction. She needs to find a treatment program that she has faith and confidence in, and then can successfully complete it. So, Ms. Mendez, ma'am, your sentence is imposed. I know I wasn't real clear on the sentence. The driving offense was a first-degree misdemeanor also. What was it, a first degree?
I think I got it that as being a first offense, so it may be a second.
So on the driving license suspended, I can only give you 60 days in jail concurrent. So you've got a 60-day sentence with the same amount of credit. You'll finish that driving while license suspended sentence long before you finish the DUI sentence. And if you find a program that you're interested in, we'll see you next week and talk more about that program. Ms. Mendez, do you have any questions, ma'am?
No, Your Honor. I want to thank you for considering the rehab program and for giving my brother the opportunity to speak for me. I do want to enter a rehab program. I just want to have the opportunity to see if I could find one that's closer. But I know that my brother did spend a lot of time and effort looking for this specific program. So
yeah, I think that we have,
Columbus
is about, I'm sorry, go ahead.
I will choose to proceed with the program.
Columbus
want
is
to
about
speak to
2
the
hours
chaplain.
away. You paused for an unusual length of time, so I think you're through speaking. You're not. I'm sorry. I don't mean to keep cutting you off. I think you're through. So finish speaking, and then I'll say what I was going to say.
Sorry, Your Honor. I was saying I do want to enter the program. I just want to have the opportunity to speak to the chaplain to see if he's aware of any other programs that may be similar or closer. But if he doesn't have any information for other programs that are similar, then I will proceed with this one.
The closest one to Columbus is about 2 hours away. The closest one we have is Crumb's Not Ladies, though. The Ladies Crumb's New Orleans. What about, is there a Promised Land in Crawfordville for ladies? What's that, an hour and what? The closest one geographically is about an hour and 45 minutes. Pensacola's roughly 2 hours. Yeah, so it's not only close to where you're at now, it's also close to your family. That's part of the equation. But we'll see what
Okay.
happens with your further search, okay?
I will accept the rehab program that my brothers found for me.
Okay, I'm not gonna do that today. I want you to talk to the chaplain and I'll see you next week, okay?
Thank you, Your Honor.
Have a good day. Thank you, sir, for
Thank
coming.
you,
And if
too.
you'll leave a number with Mr. Goodson, whether you come or not, it's up to you, but we'll notify you when she's on the docket, okay? All right,
I
thank
haven't heard that obligation.
Okay, so the program they're talking about is Team Challenge. In the 90s, I'd say about 50 miles from this town, this court is in Marianna, Florida. She lives in Dothan, Alabama. In the 90s, there was a teen challenge about 50 miles away from there in a little town called Bonifay, Florida. And it was for you. I would assume it was just all young men, boys, probably 12 to 18. And it was run like a military academy. They wore military clothes and did a lot of manual labor, did a lot of farming work. And I never heard much out of them except for every once in a while a kid would run away and you'd hear about that. But other than that, you didn't hear much about it. When my son first had the opportunity for rehab, his first rehab was a teen challenge in Jacksonville. I thought it was odd because my son was like 22, but they've got 50, 60, 70, 80, or I guess 70. I don't know if you ever make it to 80 if you're on drugs, but they've got all kinds of adults in the program Teen Challenge. It's just a rehab program. And so it's an odd program. If you're not religious, it's not for you. It was one that was, my son was definitely not religious. He definitely wasn't interested in learning anything about religion at the time. He's just being pretty resistant, being pretty rebellious. And it wasn't going to connect to him. There was nothing that they were going to do that was going to get through to him. And, and Big Tiff, exactly. I just saw your thing there. It's very religious. It's the type, hey, go pray in the corner. And if you're religious, it can work for you. But if you're not, it's not going to work for you. And it's just not a good program. You're wasting your time going there. You're wasting a good bed. Somebody else can take advantage of that. The world's got all kinds. They've got people that truly are in tune to the religion, and it can work for them. I'm not knocking anybody's religion. If it works for them, it works for them. But it definitely didn't work for my son. He ended up getting kicked out of it and ended up back in jail. So Judge Mercer's doing the right thing by telling her if she's not going to make it, don't even try it. Don't waste that bed. Someone else can use it. And there's certainly not enough rehabs out there. So yes, Adam, a manual labor rehab camp. Absolutely. Welcome to Florida. Welcome to Florida. We got all kinds of fun stuff like that. Let's jump over to Judge West in Texas. I miss her. I hadn't seen her in a little while.
Good morning. Are you Anthony Young? Yes, ma'am. And Mr. Young, you were previously in court and you entered a plea of guilty to the second-degree felony offense of theft of a firearm. And I received a pre-sentence report and I reviewed that. Has everyone had an opportunity to review that report?
Yes.
Are there any additions or corrections to that report?
Well, just to judge, I know maybe some issue with the defendant's version of what happened, of course, him accept responsibility. That was discussed with him, and he does understand, of course, what he was charged with, what he pled to, and he's definitely accountable and responsibility for what happened with that gun there.
Okay. Anything else, Mr. Smith, on that? I have also received and reviewed numerous jail incident reports that I've had an opportunity to go through. Have you both had an opportunity to review those?
I have reviewed them and discussed them.
So the agreement's for a 5-year deferred probation. How old are you? 17. I'm pretty sure if it's not the thickest packet, it's close to one of the thickest packets I have received from jail with regard to how you have been acting and misbehaving, knowing that you're about to come in front of a judge who could either accept or reject your plea agreement. Doesn't make much sense, does it, how you've been acting? So why have you been doing it?
I get irritated easily.
You do? Do you understand? You're 17, you're so young. We all get irritated easily. That's life. It's just part of life. People are going to irritate you. Your parents are going to irritate you. Your lawyer, me, your friends, your girlfriend if you have one, your wife if you end up with one. We all get irritated. But you don't act like this, and you don't talk to people who are just doing their job the way that you speak to these correctional officers. The disrespect that you're showing people who are just trying to go to work and make a living is so unacceptable that I'm not going to say the words because people are watching and it's so inappropriate. It's ridiculous what you've been doing. And then thinking that you can get high or a little buzz by drinking hand sanitizer. That was dumb. I mean, you ended up in the hospital, right? I mean, do you want to kind of have a normal life like the rest of us and go to work, go home, have a family, go to school maybe? Or do you want to spend your life in prison? You don't? So let me just tell you, the way this is looking, you're going to have to make some huge changes in your life if you don't want to go to prison. You're going to have to do things that most 17-year-olds don't do. You're going to have to grow up real quick because you're going to be on an adult felony probation. And so if you don't follow.
All right, I'm going to jump in real quick. This is Judge Nicole West. She's in Jefferson County, Texas, the same building as Judge John Stevens. So she's right down the other one. That would be a great one to go visit, too, is to see Judge Stevens and Judge West. I got a feeling, though, if you end up in Judge Stevens' room, he'd end up having you on the stand. So he may not be the best one to go visit.
The rules, it's not just a slap on the hand, or it's not just getting kicked out of school and going to alternative school. It's not those things. It's prison. And it's going to be prison for up to 20 years. You can go to prison for up to 20 years if you violate this probation. Do you understand? Let that sink in. 20 years of your life you could spend in prison for this very case right here if you don't follow all of the rules. It's a lot. So you need to don't get out of jail and then forget this conversation, okay? I'm going to do some things, hopefully, that will give you some tools up front in your probation so that you can learn how to make better decisions. Not hang out with the same people, get away from all that. It's just going to be up to you. It's not going to necessarily be easy, but the alternative is really not easy. It's prison. Right? Okay. What I'm going to do, Mr. Young, is follow the agreement that you made. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, but I'm not going to do that. That means today you're not a convicted felon. All right? We're going to talk some more about that in a minute. You're going to be on probation for 5 years. You're going to be ordered to pay a $500 fine. You're going to order to follow all of the rules, all of the conditions of probation. You don't get to pick and choose which one and go, well, I didn't get a new case, but I missed going. Or I didn't get, a lot of people think as long as they don't catch a case or they don't get in trouble again, that they're fine and they don't have to do the other stuff on probation. You got to do it all. You got to report when you're supposed to. If you test positive for drugs, any drugs, including marijuana. And I get that a lot of people don't think that marijuana is a big deal, but it's a violation of your probation. You can go to prison. It's just that simple. All the rules apply, not just some. And if you do that, then this opportunity is your day to change your life. I am going to order as a condition of this probation that you enter and successfully complete the cognitive track of the ISF program. That's a 90-day program. You'll go from in custody to that program. It's an in-custody program. It's not necessarily meant to be a punishment, but it's classes and tools so that you can make better decisions. If you go to ISF and you act like you've been acting in jail, they let me know. We bring you back. Your probation's revoked before you ever hit the streets. So you can get irritated in ISF, but you better not act like this, because you'll never even get the chance to be on probation. Do you understand what I'm saying? There's not going to be a second chance if you act like you're acting right now while you're in ISF. That's going to be your chance to prove to me that this nonsense you can grow out of just like that overnight, because it has to be overnight. I don't care who's irritating you. Do you understand? Okay. So when you get out of ISF, hopefully you're successful, you take advantage of it. You're never going to be a convicted felon if you do everything you're supposed to on probation. Being a convicted felon changes your life in all kinds of negative ways. Obviously, you can't get certain jobs, you can't live certain places, you can't go to certain schools. It puts you on a path that's very difficult. You don't have that right now. If you change your life and you do the right things, at the end of this probation, if you're successful, the case is dismissed. You're never a convicted felon. The other side to that, though, just like I've been talking about, is if you violate any condition of your probation, you're back here in court, your punishment is up to me. I could give you as low as 2 years. I could give you anywhere in between, up to 20 years in prison. Do you understand? All right, I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I really do hope you take advantage of this. Another thing I want to make sure you understand is there's going to be a little bit of time between now and when they take you to ISF. It's not very much, but it could be a couple of weeks or so. If I find out that you have incident reports between now and then, before you ever get to ISF, it's a violation of your probation. Does that understand? I know there's a bunch of you young kids that are all in the same dorm in our jail because we got younger and younger of y'all doing stuff like this. And y'all all are in there. I've read all about it in your case and everybody else's case. And you've got to kind of show who's cool and who's not and all of that. If you continue to do that and think you're cool in there, you're going to get to show how cool you are in prison. And that's a whole lot different. And that's not what any of us want for you. Okay? All right. You can go back with the bailiff.
May I just touch him?
Yes. You may. Yes, sir. Thank you for being here, Pastor.
Well, what I liked about her was she was being really nice with him. She was trying to get through to him. So if she could ever get him to straighten up, he'd do a lot better. I hate to see a 17-year-old just throw it all away that young, but I don't know. They're getting younger and younger and giving a. Now I can't really say too much. I made a mistake and I was in jail whenever I was 16. So he's 17, but I can assure you that the minute I realized what I had done and realized where my life was heading, I made sure I'd have made the change because I don't know, jail's just not for me. That's just not the world I want to live in. So let's jump over to Judge Mogan.
All right, we will go on the record in the matters 24 CF 62, 24 CF 91, 24 CF 101, State of Wisconsin versus Justin Starkey. The state appears through Assistant District Attorney Kevin Schmidt in person. Mr. Starkey appears in person in custody with counsel Glenn Keene. We're set here today in this matter for a competency hearing. Mr. Keene, is this matter proceeding? Have you been able to speak with Mr. Starkey?
Yes, I have, and on advice of counsel, he is wishing to stand mute today.
All right, he wishes to stand mute. Pursuant to Wisconsin statute 971.14 paren 4 paren B, he has the ability to stand mute. And I believe if the defendant stands mute or claims he is incompetent, the defendant shall be found incompetent unless the state proves by a greater weight of the credible evidence that the defendant is competent. All right, so therefore, Mr. Schmidt, you may proceed.
Before we do that, I'd like to make brief argument.
You may.
It's funny, this morning, Dr. Portner called me to make sure the hearing was still on. I indicated to him that I had thought the same thing. I had checked CCAP shortly before he called and saw that Mr. Starkey had gone to court in both Polk and Eau Claire and took the position. He was competent. He did not stand mute at those hearings, and the courts found him competent. I indicated to him that defense counsel had indicated to me he planned on saying he was not competent today. First words out of Dr. Portner's mouth was, is he allowed to do that? And I thought that was very sharp because Dr. Portner intuited, without being a lawyer, why judicial estoppel exists. It's to prevent people from playing games with the court, taking contradictory positions on the same issues in front of different courts. Mr. Starkey has had a Polk case for a very long time. It just recently resolved, and an Eau Claire case more recently, and then the 3 Burnett cases. He raised competency originally in Polk in October 23. He had Dr. Minter. Dr. Minter said he was competent. He agreed he was competent, took the position he was competent. Court found him competent. He then raised competency in Eau Claire and Polk around the same time in this year. If you recall, Judge, defense counsel didn't want to raise competency originally in this case because they wanted to see what happened in Polk and Eau Claire first. After the Polk competency hearing got moved for reasons we didn't know and wasn't rescheduled, we finally just set it for competency and scheduled ours. In the meantime, Mr. Starkey has gone to Eau Claire on August 26th, took the position he was competent based on the exact same report from Dr. Portner, and the court did find him competent. 3 weeks ago in Polk County, he appeared there. He was again agreed he was competent, took that position, and then was found competent. He's had a plea and sentencing in Polk County in the meantime. He's scheduled for an arraignment tomorrow in Eau Claire, where he's still taking the position he's competent. And now he's here today taking a different position. Judicial estoppel can be applied where it's the same issue in both cases. The issue in all the cases is competency. None of the fact patterns are complicated. They're all kind of samey charges. None of them involves complicated evidence like GPS or DNA or geofencing or anything like that. He's taken the position in the past two cases and prevailed on that position. The position he took was that he's competent. He didn't stand mute at those hearings. And the position he's taking today is different. I don't believe that. I believe he's playing fast and loose for calculated reasons, for strategic reasons. And I believe that he should be stopped from taking a position other than that. He's competent, as he did in Polk County and Eau Claire and continues to in Eau Claire. Thank you.
Thank you. Argument?
Yes, Your Honor. I would note that first, he did stand mute today, so he's not contradicting it. And as I noted in my reply brief, and as the court is aware, in a competency, not only the defendant, but the defense attorney, the
Well,
prosecutor.
your reply brief that was filed this morning.
Yes.
that I just was provided notice of 2 minutes before this hearing.
Yes, I understand. I was not saying that so you read the brief. I was just saying that, say that to point out that I know you're aware of the law is what I was getting at.
Okay.
I was not trying to say, I expect you to have read the argument. Okay. Mr. Starkey this morning just stood mute. And my argument is that as a defense counsel, based upon my knowledge of facts in the case, I also have an affirmative obligation to bring up competency. And if I fail to do so, I'm per se incompetent, and I find the statute in the brief I filed, but it's like State versus Johnson. So if I don't challenge competency, I'm automatically, deemed to have provided ineffective assistance to counsel.
Mr. Schmidt.
So that's half of the correct statement of the law. It's not only per se ineffective assistance counsel not to raise competency when you doubt it, but it's actually an ethics violation too. It's in the ethics rules. He has raised competency. Once you've raised it, you're supposed to take whatever position your defendant says. You could have a client who says they're Jesus Christ, and if they tell you, I want you to take the position I'm competent, if they say I'm competent, that's their decision to make. Then the attorney argues that. You don't go against their wishes at the competency hearing, and you do take their position at the competency hearing. That is clear law.
So if Mr. Starkey is standing mute or saying he's not competent today, but he said he was competent in Polk and Eau Claire, isn't Mr. Keene doing his job as an attorney and standing by his client?
Yes, what I'm getting at is this. I'm not saying Mr. Keene is doing anything wrong. I'm saying he can't use himself as a shield for Justin Starkey's decisions. Justin Starkey made the decision in Eau Claire and Polk to take the position he's competent, just as he's taking the position today to stand mute, knowing it was a different position.
So you're asking the court to take judicial notice of the Polk County case as well as the Eau Claire case, and the competency decisions and findings, as well as Mr. Starkey's admissions to competency in both of those cases, and then use judicial estoppel to find he is competent here today.
What I'm asking the court to do is what's super important for judicial estoppel, what people are stopped into doing or out of doing is taking a different position. What I'm asking the court to find is that he took the position he was competent in both of those proceedings. He should be stopped into taking that position today, which makes this hearing really a summary hearing based upon the doctor's report.
We have the doctor. Might as well use the doctor. And then I will take the argument in advance. We have Dr. Portner here. I have his report. Mr. Schmidt, you may proceed. First, I'm going to say, Dr. Portner, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do, Your Honor.
All right, you may begin.
Hi, could you state your name for the record?
Yeah, Matthew Portner.
What was your employment when you did these, when you did the assessment of Mr. Starkey?
So I'm no longer employed with the state of Wisconsin, but at the time I was a postdoctoral fellow at Mendota Mental Health Institute.
Oh, and were you asked to do some sort of assessment on Mr. Starkey?
Yes, I was asked to do a court-ordered competency evaluation.
What does that entail? What did you do?
It entails a thorough record review, although for this particular evaluation, because we are given a 15-day limit to complete the evaluation, I was not provided with substantial records, but for the records I had available, I reviewed those. It also includes observation and consultation with other members of the treatment team, how Mr. Starkey presented on the unit, his daily activities, group attendance, participation in those groups, the competency education groups of which I led. I had direct observation, as well as it culminates in a comprehensive competency evaluation conducted by myself.
So you and your staff did things together, basically.
That's correct.
So I'm going to start with your opinion and work backwards from there, if that's okay.
Yes.
So you ultimately came to an opinion that Mr. Starkey does not lack substantial mental capacity to understand the proceedings and assist in his defense. What was the basis for that?
The basis is that he was able to complete pretty much my entire interview. I did note that around minute 55, about the hour-long interview, he made some tangential remarks. But the fact that he was able to answer my questions, the fact that he was able to show a factual knowledge, he was able to show rational appreciation based on my questioning, as well as he indicated that he was able to assist his defense counsel. That was the basis for my opinion. Even before at that minute 55 mark, he had made some remarks that were peculiar and unrelated to what we were discussing.
Was Mr. Starkey able to describe all the people in courts, the judge, the prosecutor, the defense attorney?
At least for the individuals that you just mentioned, yes, he was.
And was he able to describe their roles and what they do?
Yes, he was.
Did you try troubleshooting going through a charge and seeing if he could make decisions about it and recall it?
I did. Due to the extensive number of charges he was facing, I didn't go through every single charge. However, I picked one, specifically I picked one of the most serious charges, asked if he could identify that. He was also able to list specific details from that charge, including witnesses, the potential of people that could testify against him in that case. He gave a full description of the case that was consistent with the criminal complaint, as well as we utilized that case to go through potential plea options and other court-related matters.
Was he able to describe the plea options accurately?
Yes, he was.
There's mention in here that when he didn't know information, he would use his materials to reference it. Why was that of particular interest to you?
So it was interesting that I never tell defendants to bring materials with them. I let them make the decision to. They are provided several worksheets and as well as a competency workbook when they're admitted to the unit. And if they choose to, they can bring it. I never disallow them from bringing it to the evaluation. But certainly we want to get a good idea of whether they know the information first without referencing materials. And if they struggle with materials, then we allow them to reference anything they bring. So it was important that he brought that, not only because he did know some information without referencing any of his materials, but it shows some rational appreciation that he can bring the materials and he can reference them if he needs them.
So it shows that sort of rational thought is what it shows.
That's correct.
So some of the people on the unit had some thoughts about Mr. Starkey and his seizures. What were those?
I consulted with the medical staff, both the psychiatrist. I read documentation from the on-call psychiatrist, as well as consulted with the nursing staff. And based on the fact that Mr. Starkey was prescribed anti-seizure medications prior to his admission, was continued on those medications, as well as from what the physicians observed, as well as nursing staff observed for these incidents that were described as seizure-like activity, they did not agree that they were indicative of seizure-like activity.
They believed he was malingering the symptoms.
I believe I used the word feigning, but yes, they did not state that they were true seizure-like activity.
Did any of the past competency reports you reviewed talk about Mr. Starkey feigning or malingering?
There was one competency evaluation that I reviewed that mentioned the potential of malingering, but in that report, to the best of my knowledge, the evaluator was not able to complete any malingering assessment, so they weren't able to form an opinion on whether Mr. Starkey was malingering at that time.
Okay. I have no other questions then.
Mr. Kane?
Okay, yes, Dr. Portner. What do you understand someone that you evaluate has to be aware of to be found competent, mentally competent to proceed?
To my knowledge, there are 3 basic prongs. They have to demonstrate factual knowledge, rational appreciation of plea options, as well as their understanding of their own case and charges, and they have to be able to assist their attorney.
Okay, so you said one was a rational understanding of their own case and charges. Did I hear you correctly?
Yes.
Okay. So in your report, you talk about in your interview that Mr. Starkey mentioned stolen identity and people committing crimes using his name. Was he talking about those in references to the charges he was facing in any of the counties?
I don't believe so. At the time, I redirected him because we were discussing his ability to assist his attorney. We had already gone through his charges at that point. So I redirected him and asked whether he felt that his attorney was doing a good job, to which he was able to redirect the conversation and answer appropriately.
Okay, but did he say that someone had stolen his identity and that's why he was in jail or something along those lines?
He did, I believe, mention something about a stolen identity. As to whether it was related to him being in jail, I'm not sure about that.
Okay, and did it also mentions something about someone stealing his word find puzzles? Would that be correct?
That would be correct.
Okay. So if an interview is focused on whether or not Mr. Starkey can rationally assist in his defense, would focusing on word find puzzles and stolen identity demonstrate a rational appreciation of the facts in his criminal cases that involve Mr. Starkey being arrested on a scene, Mr. Starkey being accused in one case by his mother, and Mr. Starkey in other cases that he's been charged with where he's in the custody of jail, so someone couldn't have his ID?
In those cases, I did write following each of the phrases that you noted, the paranoid ideation, as well as someone stealing the word finding puzzles. The authors of those reports stated that this did not appear to affect his ability to discuss his charges or recent potential pleas in a self-serving manner.
Doctor, I have no further questions for you.
Additional redirect?
No.
All right, you may step down. You are released. Thank you, Dr. Portner. All right, argument, Mr. Schmidt.
The doctor's report clearly shows that Mr. Starkey is aware of the facts of this case. He can rationally deal with them. He has the foresight and thinking to bring his stuff with him to reference it if he needs it. He knows who the actors are in court and what our roles are. The fact that he may or may not have delusions is irrelevant. Not every mentally ill person is not competent to stand trial. This isn't a Chapter 51. The standard is really, really low. It's understand the proceedings, know the facts, capable of learning the facts, rationalizing with the facts, helping your attorney. He's shown all that here. What's of particular concern is all the references to him malingering and feigning symptoms to try to seem worse than he is, in terms of the stroke, in terms of or the seizure strokes or whatever, and in terms of the delusions, only saying those around specific staff. I think he's obviously competent. It's what the doctor has. There's no medical testimony to contradict it. Thank you.
All right, Mr. King.
Well, first, just to note that again, it's Dr. Portner's only role is to advise the court on the court's determination. It's not like a medical diagnosis where we're asking the doctor to make the decision. Regarding the concerns, one, whether or not he was faking seizures for whatever reason doesn't really bear on mental competency. Second, when I did ask the doctor during his testimony about if he was talking about word finds and someone named Andrew and stolen identity, the doctor was not able to find out whether or not that was just in general testimony, but it was triggered when he was asked, when he was being talked to about a specific cases. So the fact that he didn't choose to bring it up every single day or other times to other staff doesn't indicate a faking of symptoms, because we don't know what he was asked by the staff. I mean, if he's asked, do you want Jell-O with your lunch, talking about someone taking his word find puzzles probably would not be relevant. And there's nothing entered in the record to state that he was asked about similar topics, i.e. his criminal cases, and then chose not to bring those up because he, knew he wasn't around the doctor.
Again, I have heard the testimony of the doctor, and I have reviewed the report and received that as evidence. The report is quite clear, and the doctor's testimony is quite clear in the fact that Mr. Starkey does understand. He has a rational and reasonable understanding of his defense and his ability to assist in his defense. And the doctor is clear in the information and evidence provided that Mr. Starkey is malingering and feigning his symptoms and, quite honestly, pretending to be worse than he is with his symptoms. I believe that the state has proven this by the greater weight of credible evidence that Mr. Starkey is competent to proceed in this case and has met its burden. That is, if the court does proceed in a competency hearing. Now, we go to the judicial estoppel evidence. And quite honestly, I believe that the state went above and beyond and proven that by a mountain. Judicial estoppel is a legal document that will prevent a party from taking a position in court that is inconsistent from a previous position that a defendant took in a different legal proceeding. And the purpose of this document is to preserve the integrity of a judicial system and to prevent parties from being dishonest and gaining unfair advantage. And that's exactly what Mr. Starkey is trying to do. Exactly. He is facing serious legal proceedings in Polk County, in Eau Claire County, and in Burnett County. And he's doing exactly that. He admitted to competency in Polk County. And so he was sentenced. He was not only did he plea, but he was sentenced in Polk County. He admitted to his competency in Eau Claire County, and he is to be arraigned on those charges tomorrow in Eau Claire County. And now he wishes to fight, or he wished to fight the competency in Burnett County, and we're dealing with the exact same report, the exact same evaluation from the exact same doctor from all three counties. And he wished to stop and not use the report and to claim incompetency for this case. So if the court would have found and said the state met its burden for judicial estoppel, and I would have granted that motion. But for the fact I hate appeals issues, hate them, hate to be overturned. So I wanted to doubly ensure that I would not be overturned on an issue. So I sealed it all up and doubled it all up. And so I grant on the estoppel, and I'm finding him competent. So both of those are done. So he's competent, the matter proceeds. And so, Mr. Keen, let's get to a status date. How long do you need to be able to look at everything and to try and get the matter?
Well, we may end up asking for a, we may end up looking at a, insanity issue. So I have to figure out.
I wouldn't say, you can't say insanity anymore.
Well, not guilty of incompetency.
NGI.
Right, NGI, but yeah.
By reason of.
Incompetent.
Insanity.
Yeah.
Right.
Yeah.
By mental defect.
Right.
Yes. All right. So you can look at that and you can try and go that route. But again, that's a bigger hurdle. Okay, so let's look at that. February 6th. Can you do 9 a.m.? We are adjourned.
All right. I love how Judge Mogan doesn't put up with it. She doesn't play the games. She doesn't listen to it. She's becoming one of my more favorite judges. She's just got an awkward as hell courtroom on the camera. It's an odd one for me. So sometimes it's hard for me to pay attention and keep up with it. Thank you guys for coming out. Thank you for watching the show. Stay safe. If it's snowing where you're at, stay inside. If it's not snowing where you're at, go and do all the work. Catch up for the people where it is snowing. Hold on a second. Hold on a second, everybody. I have something coming up. All right, I am working. Hold on a second. I'm trying to. All right, everybody. I'm trying to get the green screen off of her. Trying to figure that one out. Hey, Kathy, how are you?
Good. How are you?
Doing all right. I'm trying to get the green screen out from behind you. I can't figure out how to do it. Hold on.
Well, it doesn't let me do it.
Hold on. I think I may have figured it out. Bam. There's a brick wall behind you. Let's go to.
Oh, yeah. Wall ball.
There we go.
I'm going to get nailed.
Yep. How are you doing?
Good. How are you?
Doing all right. How was your Chinese?
It was delicious.
Okay.
It's waiting for me.
Oh, it's waiting for you.
It was too hot anyway. I'm a server. I eat cold food.
Yeah. I've been staying at hotels for the last couple of weeks, and it's almost everything I'm eating is out of a microwave. And I'm not a restaurant person, so it's hard for me to be out and about and spending money. So I'm cheap. So anytime I'm out and about, let's see what we can eat that's cold.
Now, when I travel, I have to go to the restaurants. I have to. And I get appetizers, entrees, and desserts because I have to. I'm somewhere new.
Yeah, no. Oh, I'm simple. Like my wife could literally fix me. Just She could fix me she could fix me a ham sandwich every night of the week. I don't care. I
What?
don't need anything different.
You could fix the ham sandwich.
What's that?
You can fix the ham sandwich.
Oh no. I'm not
Oh,
good at
yes.
that.
Oh, yeah, it's
No.
real hard.
No, there's been times where Emily's let me go in the kitchen and make my own food. And if I go in the kitchen and make my own food, my attempt to make a ham sandwich comes out with a bunch of ham on a plate. Because there's too many ingredients for a ham sandwich. So.
At least she keeps you alive.
Oh, she does. She does. She feeds me well. The problem is Emily's an enabler. Like with it being as cold as it is, I kind of looked at her and it's like, I want ice cream. She's like, shoot, give me a second. She took off running.
She's a saint among women. You would starve with me.
I believe I would. Sleeping in the doghouse and not getting fed.
You can get fed. You just got to go make it. It's in the kitchen.
I cannot begin to tell you how skinny I'd be if I had to feed myself.
I just had a court clip the other night of a guy who got divorced after 42 years. And he couldn't live. He could not live. He was homeless, no food, no phone, no one helping with his bills, in jail.
I would be that way. I saw a meme one time of it just showed a mattress on the floor with a box with a gun laying on the box and said, "Me if I wasn't married." And that would probably be about how I lived. Because my wife, times that we've moved, my wife's like, trying to understand what type of dresser I want or what type of that. I was like, I don't just leave it in the box. I don't care.
Just use the box. Just set everything on top of the box.
Yep. Please remind you to give Bill. So Margaret's saying, Bill, please remind you to give my hubby your number. Okay. I don't know what that means.
I don't have your number. You're giving out her hubby your number.
Yeah, I don't know.
I'm gonna get Emily's number.
There you go. Yeah. Well, the only thing is Emily doesn't answer the phone. I've actually been. I've been in the same room with her and called her just to see if she would answer the phone, and she doesn't even look at the phone if it's ringing. She don't care nothing about it.
I don't answer the phone either. Never.
Yeah, absolutely. And Adam asking how do you make ramen? I'm lost. Somehow it just comes out perfect every time she makes it. But I could figure it out. I've had my job takes me to different towns, and I've had an apartment, but I get very simple. I literally just get to a rice cooker and just cook simple stuff like that. But I'm certainly not.
Rice is yummy.
Yeah, but I'm certainly not creative. I end up getting some sort of spice called Slap Your Mama spice stuff, and you just put it on everything, and it just works. Have you ever seen that stuff? It's called Slap Your Mama.
No.
Okay. Have you ever seen Creole? It may be a Southern thing. Have you ever seen Creole seasoning?
No.
Okay, it's a Southern thing, I guess. But it's a red peppery stuff, so it's good stuff. It goes on anything. It'll make anything that's bland edible. And so, but okay. So Victoria's saying it's pronounced ramen.
Ramen. It's ramen.
Ramen noodles.
No, it's not ramen. It's ramen.
Okay, but do y'all drink soda or pop?
Coke.
Okay, everything's Coke.
We drink soda here, but just a few miles to the west, it's pop. So Pennsylvania is both.
Okay.
I season my food, Victoria, with sazon and adobo.
What did you say you season it with?
Sazon and adobo. It slaps. It's so good.
Yeah, I've never. I don't know if you're saying other stuff, but see, Kelly. I live in the South where we season our stuff with Coke, but it's a different type of Coke than what Kathy's talking about. Since I was speaking of memes, have you ever seen the meme where it says, I remember my first trip to Florida when I caught my first a bundle of cocaine, and it shows a little kid holding up instead of a fish, he ended up getting a cocaine that had been imported in.
Jeez.
And so you got snow? Everybody's talking about snow. I don't want to talk about snow.
I'm in Pennsylvania. I always get snow. Always. We always get snow.
Yeah, I went to a place. I'm trying to think. I think it was in Colorado. I went to a place where it snows all year long, and because it's between two mountains, and so therefore it never gets the sunshine to ever let the snow melt.
Oh.
And so it was just a horrible, horrible place to live. I couldn't imagine living there.
But asking us if we got snow would be like me saying, "Oh my God, did you get rain? Oh my gosh, you got shut down because it rained." So
Yeah,
snow for us is just like rain for you. Like, okay, we'll go to work. It's raining.
yeah. Well, and I was thinking about earlier because in Spartanburg, Painted Blonde's talking about that they're sliding around on the roads, and I can't understand how cold equals ice and snow because if there's no water, what's icing and snowing? We know what's causing the road to ice over. I wonder if it's just the tires, the way the tire traction, hits the cold asphalt. I don't know.
No, there's moisture in the air and that freezes. And the worst part is when it first starts snowing, first starts raining, or first when the temperatures first drop, because then the oil separates from the asphalt and then you have the ice and oil. But sliding is so when I was driving home from work tonight, we were all fine. The roads were very slippery, but we were all just cruising along. Everything was fine. And then I noticed in front of me there was a car from Virginia. And I thought, oh no, this is how we all die. So I stayed like 8 car lengths away from the car from Virginia because all of us know how to drive in ice. We know what to do if we start sliding. We know how to correct it. We know not to slam on our brakes because then we just spin and everybody gets hit. But I know this person from Virginia has no idea. So I got way, way, way back. You go ahead and you do you. I'm not going to hit you. Don't worry.
Yeah, see, here in Florida, when it rains, all we do is just put our hazard lights on and drive faster.
Yeah. Yeah. Yes. When we get slow, people drive fast and they get mad at people who take their time and are very careful. Actually, it's those people who are too careful that cause the most accidents because they're not just moving along with everybody else, they're making everybody slow down, which is not a good idea in the snow to keep stepping on your brakes. You don't want to step on your brakes in the snow. You want to go. And if you keep stepping on your brakes, that's when you slide.
Okay, so in the end, and I've driven through plenty of snow, but in the end, it's about just like we would drive in mud, on dirt roads. Just saying, don't stop, just keep, dedicate yourself to your path you're going and keep going.
Yes. Yep,
Yeah,
that's
and
what you do.
almost all my life I've had 4-wheel drive trucks, and somebody was asking me the other day, they were complaining they couldn't go to work because they didn't have a 4-wheel drive, and I was like, look, I've had 4-wheel drive trucks all my life, and I've never used 4-wheel drive. I've just, in the end, I don't know how to drive it. I don't know how I could get the advantage of it. So,
I've had some 4-wheel drives, but I didn't know how to turn it on, so I just never used it.
well, I know how to turn it on, and I know how to make it drive like garbage. Because if you have it on and you're not supposed to, it drives horrible. But I don't know how. In the end, I can drive on mud. I can drive on that, but I don't have a lot of experience on the ice and stuff. So
You
I
would
don't
be
know.
fine.
And what Linus does is whenever it's snowing there, she just normally just falls off the bike.
Into
And so that's her way.
the car lane.
Yeah, that's Linus's way of dealing with the snow is just fall and then complain about it for a week.
Lena's, I got a friend I want you to meet from California.
All right, well, we're done. We didn't have any more left.
Oh, I'm sorry. I didn't check my Discord. I was so excited about getting to your stream. I didn't check my Discord.
Oh, that's fine. I sent it, and then I have to turn off Discord because if Ozzy finds out I have Discord on, he'll send like messages every 10 seconds. and so, and the whole time I'm listening to the Discord beeps going off, I'm wondering who in that courtroom has Discord on. And then I realized it was me that had Discord on the whole time.
Yeah, I muted everybody on Discord so they can't ding me.
Yeah,
even you. You're muted.
No, absolutely. My wife's got everyone muted, including me on Discord.
I would never mute her though.
Oh no, yeah. In the end, my wife, she's convinced that her phone is the only phone in the world that automatically mutes itself and automatically turns off the ringer. I'm like, no, she knows she knows what she's doing. So Marty's saying he used to drive his Brahmer in the snow. What's a Brahmer?
I don't know what a Brahmer is, Marty.
I don't know. People have all types of cool stuff. I want to be in the snow just so I can get a snowmobile.
Yeah, they are so fun. They really are. They are so fun. And a fire in the snow and a hot tub in the snow, so fun. There's so much you can do in the snow that is so fun.
All right. Well, so we're gonna have to end this because Nan never came by. So tomorrow morning, let's all make Nan upset that she didn't come by.
Amen.
In the end, I'll put money that Nan just gave up on me. She goes, if you're not going to stream every night, I'm not investing my time in that.
Smart woman.
Yeah. Rivette saying silent mode is how she keeps her phone. Absolutely, I do too. And I'll just say, just during the stream, I've probably gotten 10 to 15 calls from work, and they'll call and I'll send them a text message. What do you want? Now, I'm not talking on the phone. You better text it.
Oh yeah, I get calls and texts all the time. I don't answer. I barely even look at them. Barely.
No.
Enough to swipe them away. I don't look at them. I don't read them.
Yeah, phones irritate me enough to where just a couple years ago I was looking at getting a flip phone. I was like, I've got to be done with the phone. And so I just wanted a flip phone, and then I've got my tablet for work, and leave that alone.
Yep. If one of my kids are there, then I'll answer maybe. Only if I feel like it. But if it's anybody else, no, I'm not answering a phone.
My 26-year-old daughter will call, but unless I've got 30 minutes to an hour to devote, I won't answer because she just talks and talks and talks.
No, I answer for Fozzie though, because he's always telling me what I'm doing wrong. Like, you're not muted. Oh, your camera's still on. Or wake up.
Yeah, he's a big help. I really enjoy talking with him. Earlier he was wanting to take his drone out in the snow, and I'm like, no, don't do it. Because taking a drone out in the snow is just like taking it out in the rain. It'll melt. It'll get everything wet, and it's all electronic, and everything will fall apart.
I think it's more waterproof than that.
Oh no, not at all. Not at all. You can get ones that are waterproof, but not the one he has. Certainly not the one he has. But I'm gonna
talk him into it.
Well, he has the warranty, so they'll replace it for free. I've been waiting to see the video he made in it because he had quite a bit of snow today.
Yeah.
And for him to get snow, that's a neat thing.
Mm-hmm.
And so, yeah, Lena's is saying she never turns on the ring on hers either. Yeah, just wait. Lena's is probably so young she doesn't remember when we used to pay for ringtones.
I remember that.
Not only did we want to hear it, we paid money for it.
Yep.
Nan is here. She made it. Nan, you see, I notice when you're not here, I get to missing you. As soon as I go into a stream, I look for Nancy and I look for Nan, and I make sure Victoria's not there. And once I make sure Victoria's not there, I can start the show. So tomorrow, I'm going to have to find someone to stream. Tomorrow, I'm just probably going to stream Judge Middleton. And every time someone says anything about Judge Fleischer, I'm just going to say who. And see how long before it just upsets people.
You really should be more scared of Victoria than you are.
No, I believe Victoria would be mad at me, and she'd get about 10 foot and already lose interest and go after someone else.
No. You would have 2 black eyes.
2 black eyes?
Yep.
2. What is she gonna hit? She gonna hit me, and you're gonna hit me?
No, I don't have to. She got it. I can just stand back and do my nails.
Yeah, I would. It's funny in the court. Normally, the judge is the one to be scared of, or every once in a while, you wouldn't be scared of the bailiff. But I'd be scared of the one yelling out the page numbers.
Yeah. Yeah.
Yeah. Yeah. No. I look. All of y'all know I like Judge Fleischer. All of y'all know I like him. I'm just gonna pick on it. But no, he's not gonna be there tomorrow. So if I'm gonna dare try streaming, I'm gonna have to stream somebody else. Or I could stream a day from last week, and when everybody asks, is this live, I can just ignore the question.
I do that all the time. All the time. Someone asked me a couple questions today, and I just ignored them because I didn't want to answer them.
Yeah. Yeah, I think I even trolled you a little bit this morning whenever you had on the O.J. Simpson trial. I was like, hey, is this thing going on too long?
Yeah, and it was. Oh man.
Well, you're on day 28 now, right?
Well, no, it's our stream number 28, but it's probably still only day like 9.
How many days is it?
I don't know how many days it is, but there are 498 videos.
Holy hell.
Yeah, that's a lot. And John is asking me what I'm going to stream next. Well, I don't know. That's a year from now.
You know, it's getting almost about the time we could do Daryl Brooks over again.
We probably could.
I'm actually starting to get people questioning it, and I love that trial. I like to actually.
Oh, so good.
Yes, absolutely.
Every second was so good.
Yeah, we had the one down in Florida where the kids shot up the school, and it's just, you know, all of it's so sad. You know, it's hard for me to even watch it. But it was so interesting how the judge was getting snappy with the lawyers during the whole trial. But whenever it makes me sad just thinking about what the jurors had to, imagine the jurors having to look at every picture.
Yeah. Yes.
And see, to me, I'd see one picture. Okay, guilty, done. We're done. No need to see all those pictures.
Yeah, you're right.
So, yep. And so Jennifer is saying we got another year, and we'll find out what happened to OJ.
Maybe it'll be a split jury. You don't know.
Yeah. Did you see that trial in Bay County, Florida, where a military contractor was suing CNN?
I saw a headline, but I didn't look into it. I didn't look at it.
It was good. It was just long and a lot. I would love it, but I couldn't commit to it. But yeah. I loved it. In the end, I think he won. Somebody said 25 million. Someone said 250 million. But the headline I saw after that was the end is near for CNN. For those types of headlines. I was like, oh no, they got an insurance policy. They'll be back to that tomorrow.
Yeah. We're doing the Heard trial right now, which is long, it's 13 days long, and it's freed up so much of my time. I can't stand it. I get to do so much other stuff now. I'm not going to do long trials all the time, but every once in a while, it's nice. It frees up my whole life.
Yeah, and I was telling Fozzie this morning, we were talking about it, and I was talking about how much commitment you put into finding new judges. I've got literally the 10 to 15 that I'll record, the 10 to 15 that I'll scroll through, and I can't. In the end, I love you having the Georgia judges on, but I can't even watch them enough to figure out what town they're in.
Yeah, I know. Oh man, I got a new judge, and I'm doing the Heard trial. Maybe I'll make a video. Oh man, it's so good. I'm gonna make a video of it because I got a new judge today that is just so good.
And see, I'm the goal whenever I started the channel was I was going to try to get it to Florida focus. And Florida, Florida we call it Sunshine State, and we've got actually something called Sunshine Laws, which says if it can be public, it has to be public. And so we've actually got laws that protect all that, and it's one of the hardest damn states to get any court from.
I can get
it's called Osceola County.
Osceola County,
yep.
And I don't remember the other county, but I get Osceola, that one. I get that one all the time. Not a lot happens, but sometimes I play it.
Yeah. They almost have like a drive-through, like a walk-up court in Osceola County.
Yeah. Yep.
But what is it? Polk County. I know you've seen the sheriff in Polk County, that Grady Judd.
I love him.
I've been doing my best to try to get some of his court, because imagine the court that where you're arrested by his sheriff's office.
Yeah, I know.
And there's no body camera. There's no body camera from that area because he's one of the only counties where his deputies do not wear body cameras. And so
I have Brevard County Sheriff. I'm going to give you that link. I'm going to send it to you in Discord. But just so you know, it's awesome, but the audio is horrible.
Yeah.
But you can get live streams from here if you can figure out a way to fix the audio. So what I've had to do was I've had to fill the left with the right for audio for not stereo. I had to fill the right with the left, and if not, only half the people could hear it when I played a clip.
Yeah.
It's still bad audio.
Yeah. So see, that's where you are that's where you're a better broadcaster than me. You're a better channel creator than me. Because at that point, nope, I'm done with that. I'm done with that one. And so
I've always had bad audio since my birth of YouTube videos. I've had bad audio.
you know, I think I told Fozzie that about 2 weeks ago. Saying, I think I told Fozzie, I was like, "Hey, look, I'd love to stick around, but I got to bail. I can't stand the audio on it."
Yep.
Because I listen to court, and something to tell your audience in the mornings whenever I come in and say good morning, and then I'm kind of quiet. I listen to the court while I'm driving. I listen to the show while I'm driving, and so I don't want to be texting hi to everybody. I'm really I love to see everybody, but I really don't want to die. I don't want to. I don't want to die, but I see someone saying hi, and I want to say hi back, and I'm like, I don't do it. Don't get caught up in it. And to be honest with you, I'm not worried about dying. I'm more worried about getting a damn ticket. I'm worried about getting pulled over for texting, and so.
True.
But Devin or Devon, I don't know how you pronounce your name, was saying Florida just took away whistleblower protections on building codes. Yeah. We don't want to do politics here, but we could go on for a few months or days over some of the boneheaded decisions by that governor. So, politics is not a good start today.
I'm not touching politics for at least 4 years. I'm not going anywhere near it. I'm not talking about it. I'm not doing anything at all. I don't care what happens. I'm not talking about it.
No. And I look, whenever I started YouTube, I actually did a politics channel at first, and I literally had to I literally had to delete it because both sides was just garbage, and I couldn't stand the politics on either side, so I had to just jump off that and get rid of that channel. And so
people come to court to forget about all that crap.
Absolutely. And yeah, each and everything. Yeah, people do the same thing with Fleischer. Luckily, I take the train. Yeah, absolutely. But Judge Fleischer's audio, I don't know if it's gotten better or we've just gotten numb to it. But I remember at first it was just horrible audio, and after a while, I guess Melissa hitting the stapler as hard as she can, just beating the hell out of the stapler, and so I hadn't heard.
I think it's a stamp. I think she's stamping the pages.
Yeah, but she's giving it hell though. She's certainly not pressing the button lightly. But it seems like it's gotten quieter lately. But I've been at work so much, so Emily's been doing the streaming lately. So
she's amazing.
Absolutely. And Victoria, just telling you how much I love you. The minute I mentioned politics, I thought about you.
I love you too, Victoria.
And I thought
more
about
than
you.
Bill.
And I thought about
I love you more than Bill loves you.
I believe you do. I'll agree with that. I'll agree with that. Well, anyways, I'm going to get out of here and I'm going to go to bed and act like I don't have to get up before your show starts in the morning.
Yep, so, it'll be there.
All right, and you got a whole bunch of good court for us in the next coming up in 6 hours.
Yep, I do.
Okay, so what time is it in Australia whenever you do your show? I'm sure Rebecca and them have told you.
I'm sure she told me, but I have no idea.
Okay. I've got Linus's time already down track. It's 6 hours off, but I can't figure out Australia. I just assume it's another
17
day.
hours ahead plus a day or something. I don't know.
Yeah, so tonight's Tuesday night, so we'll just say it's Thursday morning there.
Yep.
That's crazy. My brain can't work around that. Yeah. So Marty's asking, can you fix the camera in Judge Fleischer's court?
I don't know. They keep moving it, but it seems fine. We can see everybody.
I kind of got a feeling like the person who cleans up in there, the people that clean up, whenever they go dusting or doing whatever, if they hit the camera, they hit the camera. And we can all speculate. We can all come up with a dozen different reasons on why the camera is angled the way it is or why it's that. But I always figure out the simplest answer. The person that's cleaning it probably angled it, and it just probably stays that way. And so.
Oh no, I'm blaming Steven. Yep, I'm sticking with Steven.
I hadn't seen him lately. There's been a few other ones. Have you seen him lately?
I don't know. I don't think so. I had him on today, but that was an older clip. I replayed an older clip today. The wrong one by accident, but that's okay.
They're all good. They're all good. I'm sure whatever clip you played had Tristan in it at some point. They all do.
It didn't, but it had the Savset in. The Savset who came back in the camouflage dress.
Yeah, the one who
She was there.
came back and was competent the next time.
Yeah, yes.
Hey, but look, I can appreciate that. If the judge can convince somebody to cut out that garbage, they did a good job.
Yep.
And so.
Yep.
All right. Well, I'm going to go to sleep. I'll see you in 4 or 6 hours.
Just go to sleep. I'll see you next time.
See you next time. Thanks everybody for coming out. We'll see y'all tomorrow maybe. Bye.
Bye, guys.